Learned Senior Counsel appearing for original defendant number 3 in the revision application as well as in the writ petition submitted that first of all amendment itself is time barred and the prayers in the said amendment could not have been allowed to be amended to the suit. He would submit that the plaint itself needs to be rejected as the reliefs claimed by the plaintiff apart from declaration that he is the director of the company cannot be granted as even if plaintiff is considered as a director he cannot be declared as owner of the properties belonging to the company. He would submit that the main prayer in the suit is to declare the plaintiff as owner of the properties of the company and relied of declaration of him being a director is only consequential if the entire relief along with the pleading in the plaint are considered the plaint needs to be rejected as no such relief could be granted to the plaintiff. Sri Kantak then would submit that if the amendment is rejected and more specifically the amended prayer clause the defendant number 3 would not have any grievance as such amendment prayer clauses are clearly barred by law of limitation. He further submitted that in the written statement filed by defendant number 1 and 2 in the month of July 2004, they disclosed that the shed and the plot of the company was disposed of void sale deed dated 9/3/2004 in favor of defendant number 3 and that too with intervention of GIDC. Therefore, knowledge of the plaintiff regarding sale deed has to be construed from the date of filing of the return statement that is 9/3/2004. Accordingly, he submitted that amendment application filed to the plaint and more specifically the prayer clause for declaring such sale deed as null and void in February 2016 are hopelessly barred by law of limitation. He therefore would submit that revision application as well as writ petition need to be allowed. Learned counsel appearing for defendants number 1 and 2 while supporting the contentions raised by learned senior counsel submitted that though defendant number 1 and have no objection with regard to amendment of internal paragraph of the plaint they objected for amendment to the prayer clauses as such relief is clearly barred by law of limitation. He would submit that even the main prayer in the suit cannot be granted as the plaintiff, who was already disqualified as a director of the company, would not have been any right over the properties of the company, which is a separate legal entity in itself. Both the learned counsel appearing for the defendants would submit that the finding of the learned trial court in both impugn order are perverse and therefore need to be quashed and set aside. Sri Anthony appearing for the plaintiff while supporting finding of the learned trial court submitted that cause of action for filing the amendment arose only after the death court in writ petition numbers 279, 362 and 626 of 2006 decided on 16/1/2015 quashed and set aside the impugn order dated 28/10/2005 passed by the first appellate court and modified the order of the trial court and only thereafter amendment application was filed to include the prayer for quashing and setting aside the sale deed and the lease deed executed in favor of defendant number 3.